Hi everybody, a very warm welcome to thorough newspaper analysis for the 13th of April 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So first of all is the editorial segment. Here today also we have an Indian Express article with the title Regulating Religious Conversions to Buddhism. What is the Gujarat Freedom of Religion Act? See, please understand, in Gujarat and in a couple of other states also, there is a law. Let's talk about the Gujarat law particularly. So this Act of 2003, it states that, whenever there is any sort of conversion of a person from one religion to another, then the person has to inform the district magistrate of the area concerned, seek the permission of the district magistrate before proceeding with the formalities and the eventual act of conversion. So recently, something has happened in the state and it has come to the forefront. What is that? Some persons, Hindus, they're converting to Buddhism. And the district magistrates, they're saying that you don't have to seek my permission. Why? Because if we have a look at certain provisions of law, let's say Article 25 of the Indian Constitution, then there is an explanation which says that, Sikhism, Buddhism, Hinduism, they are part of the same religion. But the Gujarat government is now coming forward with a circular saying that no, for the purpose of conversion under the 2003 Act, Buddhism and Hinduism, they are going to be considered as two distinct religions. Now, secondly, we talk about the news updates for the day, and this is going to be followed by the legal news updates for the day. So without further ado, let's start with the article discussion and let's first see the context of it. So very recently, Gujarat government has clarified that Buddhism and Hinduism, they must be considered as two separate religions for the purpose of religious conversions in the state of Gujarat. On 8th of April, the Gujarat government, it took note of Hindus, especially and predominantly Dalits, who are converting to Buddhism in the state of Gujarat, and the state government stated that both the person who is converting himself and the person who is getting the person converted, that is to say the convertee and the person at whose instance this conversion is being done, they must inform the district magistrate and they must get their permission according to the provisions of the Gujarat Freedom Religion Act. So far, what was happening is, see, there is this law by the name of Gujarat Freedom of Religion Act of 2003. Under this act, there are certain provisions which state that if any conversion is to take place, then the permission of the district magistrate is to be sought. But when this matter of conversion was, coming before the district magistrate, then the district magistrate started saying that you don't have to seek permissions because these two, Buddhism and Hinduism, they are considered as one religion. They're not two separate religions. But the Gujarat government has now come forward and said what? That no, these are going to be two separate religions for the purpose of conversion matters. To give you a context of, how broad is this conversion or what is the data or stat here, according to Ramesh Bangar, he is the secretary of the Gujarat Buddhist Academy. As per him, at least 2,000 people, they converted from from Hinduism to Buddhism in Gujarat last year alone. So this data is with respect to conversion to Buddhism last year. So now let's talk about what does the 2003 Act govern? How does this govern religious conversions in state? First of all, let's talk about the purpose of this act. As per the state government, this act, it seeks to deal with religious conversions through allurement, through force, misrepresentation, and other fraudulent means. So the government says that the borderline underlining object of this act is that we want to deal with those religious conversions which are initiated or instituted by these factors, which is if there is any sort of allurement. Let's say a person is coming forward and saying that if you convert to so and so religion, then you'll be sent to such and such schools, you'll be given such and such jobs. So there is a financial or a better life sort of an allurement given here, or if the conversion is forceful, or if there is any sort of misrepresentation or other fraudulent means that has been used, then this particular act, it comes into picture. Secondly, there is a section in this act, which is section number 3. It criminalizes an attempt to convert any person from one religion to another, again, by these factors, which is what? By force or by allurement, by fraudulent means, by marriage. This is very interesting. This was added back in 2021, and it is a part of a lot of controversy, a lot of legal challenge. So what essentially section 3 is saying, that if there is any person who's trying to convert another person from one religion to another by use of force, by use of any allurement, by use of any fraudulent means, or by marriage, or by getting a person married, or by aiding a person to get married, then this particular act of this attempt of conversion, it is criminalized. Section 3A, it was inserted through an amendment in 2021. It allows any person who is aggrieved or any person who is related to this aggrieved person to come forward and lodge an FIR for the offense which is committed under the 2003 Act. Now, anyone who violates the provisions of Section 3, they can be punished with up to 3 years imprisonment and a fine of up to rupees 50,000. If the victim is a woman, a minor, or a person of scheduled tribes or scheduled castes, then this punishment is further enhanced. So what is the enhanced punishment? The imprisonment term, it is increased to 4 years, and the fine is enhanced to rupees 1 lakh. This is the maximum fine that can be imposed for this violation of Section 3. For valid conversions to take place, okay, so now a question might arise in our minds, and very rightfully so. So does this mean that the state is, interfering to such an extent in the private realm, private life of an individual, that it is not allowing anybody to convert? Is that the situation? What if, somebody is willingly out of his own volition is, seeking the conversion? Then what happens? So here there is a provision in this law which addresses valid conversion. So for valid conversion to take place, Section 5 provides that a person who is performing the conversion ceremony, or the person who takes part directly or indirectly in such ceremony, must receive prior permission from the district magistrate, and the person who is converted must inform the district magistrate post this ceremony or following the ceremony. And if there is a failure on part of all of these persons to inform the district magistrate, then that also is a punishable offense. And what is the punishment? It is up to 1 year or fine of rupees up to 1,000. This 2003 Act, it was amended in 2021 to a great extent, and a couple of provisions were added. So 2021 amendment, it criminalized conversion through marriage under Section 3, and it introduced a couple of other provisions. So it introduced the punishment for conversion through marriage. That punishment is given under Section 4A. A law declaring marriages void if conversion takes place before or after said marriage, that's under Section 4B. Then a punishment for every person who is a part of an institution or an organization that participates in unlawful convergence of religions, that is punishable and catered to under Section 4C. This amendment, it also places the burden on the accused to prove that the conversion did not take place through unlawful means. So there is a reverse burden of proof, and there is a presumption that the conversion was unlawful, and the accused has to now establish that no, the conversion was not through unlawful means. It was not through unlawful means. So now let's talk about why did the Gujarat government issue the circular. See, the circular was issued by the Home Department on 8th of April. This circular, it states that the procedure as per the 2003 Act, the rules which are made under this Act, they are not being followed. I'm sorry, not the rules. The circular stated that the procedure as per rules, or to say the procedure as provided in this Act, they are not followed when it comes to applications to district magistrates for conversion from Hinduism to Buddhism. The circular further states that concerned offices that disposing such applications while stating that under Article 25, Clause 2 of the Indian Constitution, Sikhism, Jainism, Buddhism, they are included within Hinduism, and so the applicant is not, under a duty to take permission from such magistrate for such sort of a religious conversion. This is a reference to the explanation which is provided in Article 25, which guarantees freedom to profess, practice, and propagate religion. Under Article 25, Clause 2, Subclause B, laws, they can be enacted to provide social welfare or reform to all classes and sections of Hindus. And the explanation for this section, it states that the reference to the term Hindus, it will include persons who are professing Sikh or professing the Sikh, Jain, and Buddhist religions. So therefore, this confusion it came about. So now let's talk about whether this act it is facing any legal challenge or not. So in July 2021, the Jamaat Ulama-e-Hind, it challenged this particular act. It challenged the Gujarat Freedom of Religion Amendment Act of 2021 and requested a stay on the provisions regarding conversion through marriage. So it was argued in their plea that the new provision, it operates on a presumption. What is that presumption? That an interfaith marriage, it is being taken, and it is the interfaith marriage is being performed with the sole objective and agenda of conversion. So this is the presumption as per the petitioners, that this law, this amendment is operating on the presumption that an interfaith marriage, it is taking place for the sole purpose of conversion, when in actuality marriage has no bearing on conversion. So now let's see what has been the judicial approach on this. So the bench, comprising former Chief Justice Vikram Nath, who is currently a Supreme Court judge, and Justice Viren Vaishnav, granted a limited stay on most of the provisions of the Act in August of 2021. The bench stated that the provisions shall not operate merely because a marriage is solemnized by a person of one religion with a person of another religion. So merely because there is an interfaith marriage, the provisions of the 2003 Act will not kick in. Such marriages cannot be termed as marriage for the purposes of unlawful conversion. However, the court did not bar the operation of the Act in cases that do not concern interfaith marriages, while stating that the above interim order, it is provided only to protect the parties who are solemnizing interfaith marriage from being unnecessarily harassed. The larger challenge to the 2021 amendment, it is still pending before the Gujarat High Court. Now, please note, the limited stay, it was challenged before the Supreme Court also a month later. Now, before the Supreme Court, there are a couple of other similar laws from the various states also which are under challenged. So, if you remember, in 2021 and 2022 also for that matter, there was a lot of debate around, these laws which seek to, so to say, prohibit these motivated religious conversions. And there was a lot of, debate on technicalities, on moral grounds. So, this case, it has been now tagged with larger challenge to the constitutionality of anti-conversion laws in UP, in Madhya Pradesh, in Uttarakhand, in Himachal Pradesh, that was filed by the organization Citizens for Justice and Peace. The Apex Court is currently considering whether it should transfer these various pending challenges to anti-conversion laws across the country to itself, so that it can club all these matters together and then start with the hearing of these matters, and eventually maybe can give put an end to this particular debate. So now with this we proceed to the next segment. So now we proceed to the national news category for today, and this is the first update. India is at the 10th position in Cybercrime Index. Russia tops the list. So please remember who is at the top of this list? Russia. And what is India's rank? It is at 10th position. So India, it has now been ranked at number 10th in the cybercrimes category across the globe. And if we talk about what sort of crime is very prominent, then it is fraud involving people to make advance fee payments. This study, it is as per a new research that was conducted by cybercrime experts. They surveyed a lot of cybercrime experts across the world. An international team of researchers has compiled the World Cybercrime Index. This index, it ranks roughly 100 countries and identifies what are the key hotspots for these crimes. Next up is another important update with respect to your current affairs. So HDFC Bank, it has become the first private bank to open a branch in Lakshadweep. Private lender HDFC, it has opened a branch at Kavarati Island in Lakshadweep, thereby becoming the only private sector bank to have a presence in the UT. Moving on, give me just a moment. My screen is just stuck. Next up is an update in the category of important days. International Day of Human Space Flight 2024. So on 12th of April, International Day of Human Space Flight, it was observed. Now, a question might arise as to what is so special about April 12th, why April 12th, and what is this day about? See, April 12th is observed as the International Day of Human Space Flight because for the first time, a human stepped into space on this particular date way back in 1960s, in 1961. So now let's talk about the history of this particular day. The United Nations General Assembly on 7th of April in 2011, it passed a resolution to establish the International Day of Human Space Flight on a particular day every year. Let's talk about the history of it. So the first human-made satellite called Sputnik 1, it was launched into the outer space by the Soviet Union in 1957, thereby paving the way for space exploration. So the first satellite that made its way, human-made satellite, into the outer space is what? Sputnik 1, and this happened in 1957. Now, 4 years later, another momentous occasion happened in the segment of space exploration. What was that? The first ever human stepped into space in the year 1961. It happened on 12th of April. And who is this person? It is Yuri Gagarin. He's a Russian cosmonaut. Yuri Gagarin, you may keep a note of the name. And this happened in 1961. And the satellite, the spacecraft, which he used was Vostok 1. So therefore, this day is celebrated on 12th of April. Okay, so next up is the international news segment. Lindy Cameron, she's UK's chief of cyber expert. She's now been named as the new envoy to India. The United Kingdom has appointed Lindy Cameron as the first woman British High Commissioner to India. That's it. For the purpose of this news, just remember this name. India ranks third with 67 unicorns, Hurun Global Unicorn Index 2024. The global unicorn landscape, it has witnessed significant developments and challenges, and those developments and challenges have been highlighted in the Hurun Global Unicorn Index for the year 2024. So now let's talk about the top 3 countries here. So the list, it is topped by United States. It has maintained its lead. Then the second position is with China. And the third position is with our very own country, India. And India has how many? 67 unicorns. Let's talk about this index. So the Hurun Research Institute released the Global Unicorn Index 2024, a ranking of the world's startups which are founded in 2000s, worth at least $1 billion and not yet listed as on the public exchange. Next up is the legal news segment for today. So we have an update from the Supreme Court here, and this is a very important update for the evidence law. This is with respect to Section 27 of the Evidence Act. The name of this case is Ravi Shankar Tandon versus State of Chhattisgarh. So here the Supreme Court is stated and observed to use statement of accused on fact discovered or fact discovery prosecution must establish no one else had information about it. So now what is section 27 and what is this observation about? First of all, let's talk about section 27. Section 27 marginal note is how much of information received from accused must be proved. So if let's say information, so much of information is received from the accused. Now, how much of this information that has been received from the accused, it is to be it may be proved, provided that when any fact is deposed to as discovered in consequence of the information which is received from a person who is accused of an offense in custody of a police officer, then so much of such information, whether it amounts to confession or not, as relates distinctly to the fact thereby discovered, may be proved. So let's say if the accused said that, the murder weapon or the dead body, it is hidden at such and such place in my house, and the police goes there and the discovery is made. So now what part of this statement it can be, proved. That is the substance of section 27. Now with respect to sections 27, the court has said this, that to convict an accused based on the statements that the accused made under section 27 of the Evidence Act, the prosecution has to establish that the fact that the discovery of the evidence based on the statement made by the accused under 27 of the Evidence Act must not be known to anyone before the information was given by the accused. To put this complex observation very simply, court simply said that if you want to use that statement under section 27 for the purpose of evidence or as evidence, then the prosecution has to establish that the police was able to discover that, let's say the murder weapon or the dead body or anything in pursuance of the information given by the accused only. Nobody else knew about the whereabouts of that thing that has been discovered except for the accused. And it is only on the strength of the accused person's statement that the discovery has been made. So the prosecution will have to establish that before the information given by the accused person, on the basis of which the dead body was recovered, nobody had the knowledge about the existence of the dead body at the place from where it was recovered. So with this, we've come to an end of our TNA. Thank you so much for being with us and have a wonderful day ahead.